just now in Dr. Six's class, she was explaining about the topic called easement. Do you understand the topic? Because I think I don't really understand it. Can you share some of your knowledge to me?
Okay, Shavina, let me enlighten you on what easement is. So basically, easement is the right given to the owner of a dominant land over the owner of a Servian land. And this is actually governed by Section 282, subsection 1 of the National Land Code. And this right is given to either use the Servian land or prevent the owner of the Servian land from doing certain acts on his land. For an example, the right to light over the Servian land prevents the owner of the Servian land from using his land to inhibit the light over the dominant land. And there are two types of easement here. Firstly, the positive easement. So basically, positive easement is where you allow the Servian landowner to use his land in certain ways, while the negative easement is vice versa. You prohibit the owner of the Servian land from using his land in certain ways. But then I kind of don't understand what Section 283 subsection 2 of the National Land Code means. Can you enlighten me on it?
Okay, Natasha, based on section 283 subsection 1 of the NLC, the right said in section 282 of the NLC does not include the right to take anything from the Servian land, and also it does not include any exclusive possession rights over anything on the Servian land. However, maintenance towards the Servian land and also installation for the benefit of the dominant land is allowed. So that is basically what easement means according to the NLC.
Okay, Shavina, thank you so much.
Servian land must be defined.
Karuna, do you know what are the 4 characteristics of easement that Dr. Sik mentioned just now? I can't remember it.
It was based off the case of RA and Part 1955. So basically there's 4 characteristics that she mentioned. If I'm not mistaken, the first one must be there must be a dominant and Servian land. The second one is that the easement must accommodate the dominant land. The third one would be the dominant and the Servian must be different persons. And the fourth one would be the right granted must be capable of forming a subject matter of grant. So for the first two one, there must be a dominant and Servian land. The owner of the dominant land obtains an enhancement or increase in his rights over his land, and the Servian landowner suffers a corresponding decrease in his rights over his land. An easement is a right against the land of another. It is obvious that there must be a Servian tenement. The requirement of a dominant tenement is less obvious. It means that the benefits of an easement must be annexed to a definite plot of land so that the occupiers of the plot only benefit the rights. Next, on the easement that must accommodate only the dominant land. The easement cannot exist independently or unattached to land. In addition, there must be sufficient relationship or nexus between the dominant and the Servian land. The requirement that the right must accommodate the dominant tenement has been illustrated in the case of Hill and Tupper. The facts of this case is where a canal company granted a riparian owner the exclusive right to put pleasure boats in the canal. It was held in this case that the right did not amount to an easement, and therefore the grantee of it could itself maintain an action against another person who put pleasure boats in the canal. It was further said that no doubt the right accommodated the plaintiff's pocket, but it did not accommodate his tenement. What about the other two characteristics?
Okay, the two other characteristics is that the owner of the dominant and Servian land must be different people. This is because if the owner of the both lands are the same, then there cannot be an easement to create a benefit for the other land. And the fourth characteristic is that the right granted must be capable of forming a subject matter for grant. For example, it must be sufficiently definite.
In which circumstances do you think easement is established?
There are a number of ways in which easement can be created. So the first is an express grant by Servian owner to the dominant owner, or by the express reservation of the right when the dominant owner sells part of his land to the Servian owner. An expressly granted or reserved easement will only be legal interest in land if it is created in deed in respect of registered land completed by registration.
Okay, Zu, do you think there's any case to support this statement?
Yes, there is. So one of the cases is Datin Sri Haja and Murugasu. So there's a principle that was laid down, which is it makes it incumbent for the granting of easement by express grant and as provided by Section 286, Such grant can be only made with an agreement of the proprietor of the servient tenement and effected by way of executing an instrument in Form 17A. In some cases, an easement may be created by implication. An easement will only be implied if it is necessary to so imply it. The parties had a common intention at the time of the sale of the land that there would be an easement by the operation of Section 62 of the Law of the Property Act 1925, where the land was previously in common ownership and the common owner exercised over one part of the plot a right which could have been an easement if the plots were separated in separate ownerships. The exercise of the right was continuous and apparent, and the exercise of the right is necessary for the reasonable enjoyment of the dominant land. This is known as the rule in Wealden and Burroughs, 1879.
Great doing business with you, babe. This should help us both.
Rafe, got a farming favor to ask. The water source is kind of far, and I'm planning on setting up a sprinkler. Do you mind if I run the pipes to your land?
Well, I've got my crops, but let's sort this out. No conflicts, right?
Exactly. Let's put this into writing to avoid any issue. You keep farming, and I won't mess with your livelihood.
And Barbara, I need to ensure my crops are safe. So how about you pay for the water you take from my land?
Fair deal. We can figure out a monthly payment. Oh, and one more thing. Can we agree on no fertilizer or poison will get into my water?
Sure, let's add that. Clean water for your crops and clean deal for both.
Great doing business with you, babe. This should help us both out.
Agreed, Barbara. Happy farming!
Okay, so under Section 291, the register is empowered.
Just now, there are situations where easement is established, other situations where it is not established.
Yes, there is a situation where easement is not established. So under the English common law, an easement may be terminated or extinguished either by statute, by release, or as a result of unity of lots. Under the National Land Code, there are several ways which an easement can be terminated. Firstly, under Section 289 of the NLC, an easement granted can be released at any time by the dominant owner using Form 17C.
So secondly, under Section 290, easement may be terminated by operation of law when the following conditions are satisfied. The dominant land and the servient land is vested under the same owner, no lease, tenancy or charge is entitled to the benefit thereof. Thirdly, the servient land is neither subject to any lease or tenancy nor occupied by any chargee. So Zu, is there another specification under the provision Section 291?
Yes. So under Section 291, the register is empowered to cancel the registration of any easement or on any of the following grounds. So the easement has been extinguished pursuant to Section 290. Secondly, the form for which the easement was granted has expired. Thirdly, the easement has been abandoned by the dominant owner or the purpose of easement impedes the reasonable use of servient land. And finally, the easement is obsolete or it impedes the reasonable use of the servient land and that its cancellation will not injure any person entitled to the benefit thereof.
Barbara, we've got a tricky situation here with the easement termination list. The dominant owner wants to release it under Section 289.
I see. Have they considered the condition for termination by operation of law under the Section 290?
Yes, but it's complicated. The lands are now owned by the same person. So we need to make sure that no lease or tenancy benefits from it.
How about Section 291? The registrar can cancel the registration on buyers of grant. Maybe we can explore the option then.
Definitely. If the easement impedes reasonable use or if it's become obsolete, cancellation might be a viable solution. But we had a case dismissed due to failure to meet formal requirements, just like the Majlis Agama Islam case.
Right. The absence of proper registration and documentation can be a deal breaker.
Yes, in Chiatek Kwang, the court ruled against an easement because there was no clear necessity for the claim right of way.
Right, necessity and benefit are crucial factors.
And non-compliance with statutory provisions can be another stumbling block. The case of Tan Ah Tao is a good example where zoning regulations played a role in rejecting an easement claim.
So, as we build our case, let's focus on this pitfall and strengthen our case accordingly.